Thank you. It's a great pleasure to be here, as I have in the past, to speak at the Chicago Humanities Festival. Thanks for coming out on this kind of chilly morning. I just want to say that I will be speaking for a while, and then we want to leave about 10 to 15 minutes for questions or comments from the audience when I'm finished, so please feel free at that point. There will be people with microphones, just raise your hand and somebody will identify you and give you the mic to ask a question. The Civil War and Reconstruction transformed American society in innumerable ways. And of course, we're still debating many of the consequences of that era, debates over Confederate statues and many, many other things. But maybe the most tangible legacies of that era are the 13th, 14th, and 15th Amendments to the U.S. Constitution. They wrote a new definition of American citizenship and the rights it entails into the Constitution. They forged a new relationship between Americans and the national state. This is why my book, which is just published, is called The Second Founding, because I want to emphasize that these changes were not simply minor tweaks in an existing structure, but they really created a new constitution, a fundamentally new document. But these constitutional amendments have not achieved widespread recognition as central documents of American history, along with the Declaration of Independence, the Emancipation Proclamation, and others. And their authors, men like James Ashley, John Bingham, congressmen like that, are hardly household names in the United States. Now, Reconstruction was both a time period that followed the Civil War and a historical process, the process by which this country tried to come to terms with the consequences of the war, the most important of which were the preservation of the nation and the destruction of the institution of slavery. One might almost say that we are still trying to work out the consequences of the end of slavery in this country, and in that sense, Reconstruction never ended. Now, I've devoted a lot of my career to studying that period after the Civil War, but I have to acknowledge that most Americans know very little about it. But the fact is that Reconstruction is part of our lives today, or to put it another way, many of the questions facing us as Americans are Reconstruction questions. Who is entitled to American citizenship? That is being fought out as we speak on the border between the United States and Mexico. Who should have the right to vote? That's being fought out as state after state try to suppress the ability of some citizens to vote. How should we deal with terrorism? Not terrorism from abroad, but homegrown American terrorism, the Ku Klux Klan and groups like that that flourished in Reconstruction. And of course, every session of the Supreme Court adjudicates questions arising from the 14th Amendment, particularly. Reconstruction is also a prime example of what I want to call the politics of history. What I mean is the way in which historical interpretation both reflects and helps to shape the time in which the historian is writing. The historiography of Reconstruction is a long, complicated story, which I don't want to go into in any depth, but for most of the 20th century, what we call the Dunning School, named after my long-ago predecessor at Columbia University, William A. Dunning, and his students, dominated historical writing and popular consciousness. In their view, Reconstruction was the lowest point in the saga of American democracy. It was a time of misgovernment and corruption caused by the misguided decision to give the right to vote to African-American men who, according to these scholars, were simply incapable, innately incapable of participating intelligently in American democracy. How can we account for the longevity of this period, of this view of Reconstruction, which lasted into the 1960s or even later? The explanation is that it harmonized with the racial system of the United States from around 1900 until the civil rights era of the 1960s. This is the politics of history, because there were strong political lessons from this what I would call fake history of Reconstruction. First of all, it was a mistake to give black men the right to vote. Therefore, the white South was justified in later taking away the suffrage from African Americans. Secondly, Reconstruction was imposed by Northern outsiders. Maybe some of them were even motivated by humanitarian concern, but the result proved that Northerners simply do not understand race relations in the South, and the white South should resist outside calls for change, which accelerated in the 1930s, 1940s. As late as 1944, Gunnar Myrdal, in his famous book, An American Dilemma, wrote that when pressed about the black condition, he said, white Southerners will regularly bring forward the horrors of the Reconstruction governments. If African Americans regained their constitutional rights, the horrors of Reconstruction would reoccur. Now, when the Civil Rights Revolution took place, this outlook, this interpretation fell to the ground because the racism that was at the bottom of it was no longer tenable. And today, most historians see Reconstruction as a noble, if unsuccessful, effort to establish, for the first time in American history, an interracial democracy. It was a precursor of the modern civil rights revolution, which was sometimes called the Second Reconstruction. Now, to understand how Reconstruction reshaped our history in significant ways, we have to remind ourselves of the status of African Americans when the Civil War broke out. There were about 4 million slaves in the United States in 1860. Slavery was powerful, expanding, and economically thriving. Don't listen to anyone who says it would have just died out on its own. It was not going anywhere. There were more slaves in 1860 in the United States than at any moment in our history. The power of slavery shaped the definition of American nationality, giving it a powerful racial dimension. On the eve of the Civil War, no black person, free or slave, could be a citizen of the United States. That is what that's what the Supreme Court said in the Dred Scott decision of 1857. The only people before the Civil War who advocated a non-racial idea of nationality was the abolitionist movement, black and white. They not only fought against slavery, but also for equal rights for free African Americans. Black political conventions before the Civil War consciously chose to call themselves conventions of colored citizens. Sounds a little awkward, but this was a statement in the face of white America. They were claiming a citizenship, the right to citizenship that the larger society denied them. They put on the agenda a definition of citizenship based on birthright, being born in the country, not on the concept of race. And that is what came about during Reconstruction. Let me also just mention that in discussing these constitutional amendments, I am not trying to do what lawyers and judges do and try to ascertain the quote-unquote original intent of the 13th, 14th, and 15th Amendments. First of all, no historian believes that any important document has one single original intent or meaning. The 13th, 14th, and 15th Amendments were enacted not at one moment, but over the course of 5 years in response to rapidly evolving political and social imperatives. It was a dynamic situation in which people's views underwent rapid change. Freezing understanding of the amendments at their moment of debate or passage misses this dynamic quality of the era. It's certainly the job of the historian to try to ascertain what those who framed and debated and ratified these amendments were trying to accomplish. But those intentions have to be looked at throughout the society, not simply in congressional debates and court decisions, as is too often done. In her memoirs, written in the 1890s, Elizabeth Cady Stanton, the great feminist, recalled that Reconstruction, she wrote, quote, involved the reconsideration of the principles of our government and the natural rights of man. The nation's heart was thrilled with prolonged debates in Congress and state legislatures, in the pulpits and public journals, and at every fireside on these vital questions. Basically, my book takes as its principle Stantons Statement and says these debates out in the larger society, not just in places of lawmaking, are part of the meaning of the Reconstruction Amendments. To understand the amendments, we have to go beyond the courts and Congress to consider popular constitutional ideas throughout American society. So with that as a background, let me just look briefly at each of these three amendments and what they were trying to do. The first was the 13th Amendment, ratified in 1865, which irrevocably abolished slavery throughout the United States, even as it inserted the word slavery for the first time into the Constitution. The founders had protected slavery, but they used circumlocutions such as other persons or persons held to labor. Why was the 13th Amendment necessary anyway? Hadn't Lincoln in the Emancipation Proclamation freed all the slaves? On January 1st, 1863, Lincoln declared free over 3 million slaves. But the proclamation, although a turning point in American history, left in slavery 750,000 people, most of them in the border states, the 4 slave states that remained in the Union: Delaware, Maryland, Kentucky, Missouri. The proclamation was a military measure against the Confederacy. It had no bearing on those 4 states that were still in the Union. They were not fighting against the government in the Civil War. Lincoln also exempted some parts of the Confederate South. And indeed, so that it's also true that freeing individuals is not quite the same thing as abolishing slavery. Slavery is created by state law, and those laws have to be abrogated or repealed. In fact, even after issuing the proclamation, Lincoln still pushed for state-by-state abolition, which was his favored method of getting rid of the institution altogether. Contrary to what one might conclude from a fairly recent Hollywood movie, abolitionists, not Lincoln, originated the 13th Amendment. The campaign was coordinated by the Women's National Loyal League, headed by Susan B. Anthony and Elizabeth Cady Stanton. And in early 1864, they delivered a massive pile of petitions calling for a constitutional amendment abolishing slavery to the Congress, whereupon Senator Charles Sumner from Massachusetts proposed a 13th Amendment based on the 1791 French Declaration of the Rights of Man and the Citizen from the French Revolution. Sumner's proposal said, "All persons are equal before the law, so that no person can hold another as a slave." Senator Jacob Howard of Michigan urged Sumner to forget about French laws, French constitutions, and French codes, and go back to, quote, good old Anglo-Saxon language. The United States has always had a somewhat tricky relationship with France, mostly because there's only room in the world for one universal nation. And both the United States and France think they are that everyone else in the world ought to be just like us. So there's this kind of tension. But anyway, the final language of the amendment did go back to familiar Anglo-Saxon language. It was taken almost word for word from the Northwest Ordinance of 1787, to which it had migrated from Thomas Jefferson's proposed Land Ordinance of 1784. And it said, "Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States." That's very sweeping, but the provision allowing involuntary servitude for those convicted of crime is an excellent illustration of the aphorism that historians write with one eye, at least, focused on the present. For decades, scholars writing about the 13th Amendment, including myself, paid no attention to what we call this criminal exemption. But with mass incarceration and the widespread use of prison labor suddenly national issues, it has attracted a lot of attention. including in the Hollywood documentary a few years ago, 13th, which traces a straight line from the 13th Amendment to mass incarceration today. But in fact, the coupling of a ban on slavery with a criminal exemption long preceded, as I said, the 13th Amendment. It originated with Jefferson. Scholars have not fully explained why Jefferson included this in the 1780s in the first place. When I was working on my book, I called up a couple of my former graduate student colleagues from long ago who are now scholars of Jefferson, and I said, why did Jefferson include this exemption for prisoners? And both of them gave me the same answer. I haven't the slightest idea. So that's the state of the historical investigation at the moment. But the fact is, that wording by 1865 was totally familiar. It was in the constitutions of just about all the northern states that had barred slavery. It was what we might call boilerplate language, and it attracted no discussion, really, in the press, in the debates in Congress, but it did open a loophole which would later allow for the widespread use of convict labor in the South in the late 19th century, where mostly for African Americans who would be convicted of petty crimes like stealing a chicken, sent to jail for 10 years or something like that, and then leased out to work on plantations or railroads or mines. This was not what the people who wrote the 13th Amendment had in mind, and sometimes unanticipated consequences are as important as the original intent. Well, abolitionists saw the 13th Amendment as the beginning of an even deeper transformation. What we might today, using a term that wasn't around back then, we might call it regime change. That's what they're after. They're trying to change a pro-slavery regime, which is what the United States was from the Revolution to the Civil War, into a regime committed to the ideals of freedom and equality. Most Republicans were not abolitionists, but they all shared the point of view that, first of all, slavery was the cause of the Civil War and the death of 750,000 Americans. Slavery had deprived its victims of the basic rights to which all persons were entitled. It had done more than oppress slaves. It was a cancer that degraded white labor and threatened all Americans' essential liberties, such as freedom of speech and freedom of the press. The 13th Amendment aimed to change all of that. Unlike the Emancipation Proclamation, it applied to the entire country and for the first time made the abolition of slavery an essential part of the country's legal order. The one question of the age is settled, declared one congressman. But if it resolved the fate of slavery, the 13th Amendment opened up a host of other questions. What exactly was being abolished? Property in human beings? Well, certainly. What about the racism that was essential to American slavery? Racial inequality, was that being abolished? What would be the status of the former slaves, and who would determine it? What did it mean to be a free person in post-Civil War America? These were the questions on which the politics of Reconstruction persistently turned. Now, white Southerners had their own answers, as became clear when Lincoln was assassinated and Andrew Johnson, as vice president, became president. Johnson used to be lionized as a heroic defender of the Constitution against the radical Republicans. Johnson today has a strong claim to being considered the worst president in American history. There are other claimants, but Johnson is a contender anyway. He lacked all of Lincoln's qualities of greatness. He was deeply racist. He had no sense of public opinion. He could not work with Congress. Johnson set up new governments in the South, completely under the control of white Southerners, and they moved to severely restrict the rights of black Americans, or the former slaves. They enacted laws called the Black Codes, which gave blacks virtually no civil or political rights and required black men to each year sign a labor contract to work for a white employer, and if they fail to do so, they'd be arrested for vagrancy, fined, and then sold off to work for the year to anyone who would pay their fine. These laws alarmed the Republican Party, which controlled Congress, into thinking the South was trying to restore slavery in all but name. And in early 1866, in response, they enacted one of the most important laws in American history, the Civil Rights Act of 1866. This was based on the 13th Amendment. It was an extension of the idea of abolishing slavery. The Civil Rights Act states that anybody born in the United States, except Native Americans, are citizens of the United States. Native Americans are still considered citizens of their tribal sovereignties at this point. This is birthright citizenship, a statement that anybody can be a loyal American. Race, religion, national origin do not matter, nor does the legal status of one's parents. It severs citizenship from race, as the abolitionists had long demanded. The idea remains controversial. As I said, it's still being fought out today. President Trump, not long ago, claimed the right to basically abrogate the first section, the Civil Rights Act, and later the 14th Amendment, which also includes this, by executive order for American-born children of undocumented immigrants. But the language is very clear. It doesn't matter what the legal status of your parents are. If you are born in the United States, you are a citizen. The law went on to declare that all these citizens have to enjoy basic legal equality. The Civil Rights Act didn't say anything about the right to vote, but it guaranteed equality of civil rights, particularly the right to sign contracts, own property, testify in court. These are the rights of free labor necessary to compete in the economic marketplace. The language is interesting. All citizens, it says, must enjoy these rights the same as enjoyed by white persons. In a sense, that language still sees whites as the default citizens, but now the concept of whiteness is changed as a legal notion. Before the Civil War, whiteness was a boundary, a barrier. When there were laws saying only white people can serve in the militia or only white men can vote, that's to exclude others. Now, whiteness is a baseline. People have to enjoy rights the same as enjoyed by white persons. That is a complete change it hasn't been emphasized enough in the literature, in the whole concept of law in American society. Andrew Johnson vetoed the Civil Rights Bill, and it became the first important law in American history enacted over a veto. And Johnson's veto message denounced the law for what we now call reverse discrimination. Quote, "The distinction of race and color is by the bill made to operate in favor of the colored and against the white race. Indeed, in the idea that expanding the rights of non-whites somehow punishes the white majority, the ghost of Andrew Johnson still haunts our discussions of race." But of course, a law can be repealed by the next Congress. So very soon, Congress put these principles into the 14th Amendment, the most important change in the Constitution since the Bill of Rights. It's long, it's complicated, it deals with things that are no longer relevant, like it says that Southerners are not going to get any monetary compensation for the loss of their property in slaves. It contains a convoluted clause about saying that states will lose representation in Congress if they deny the right to vote to any group of male citizens. This raised an outcry among the era's feminist movement because it introduced this gender distinction for the first time in the Constitution. But the heart of the 14th Amendment is the first section. It begins by again saying anyone born in the United States is a citizen, and it goes on to bar the states from abridging the privileges or immunities of citizens or denying to any person, whether citizen or not, the equal protection of the laws. The Civil Rights Act had listed specific rights that people were to enjoy. The 14th Amendment is written in the language of general principles, equal protection, due process, privileges and immunities. It leaves it to future Congresses to breathe meaning into these phrases. Equal protection is the most radical change in that section. The word equal does not appear in the original Constitution, except for a clause about what happens if two candidates for president receive an equal number of electoral votes. The 14th Amendment now makes the Constitution what it never was, a vehicle through which aggrieved individuals and groups who believe they're being denied equality can take their claims to federal court. And the language is race neutral. It doesn't say anything actually about black or white. It's about citizens and persons. And this has had enormous consequences in our own time. The courts recently have used this to expand the legal rights of all sorts of groups, most recently gay men and lesbians in the gay marriage decision. That's a 14th Amendment decision based on the equal protection of the law, even though obviously people in 1866, the gay marriage was not on the political agenda when the 14th Amendment was being discussed. So this section fundamentally changed Americans' relationship to the federal government, and it proclaimed that everyone in the United States was to enjoy a modicum of equality protected by the national government. As one newspaper editor said, the 14th Amendment changed a constitution for white men into a constitution for mankind. All three of these amendments also marked a fundamental change in the federal system, that is, the relationship between the national government and the state governments. It not only put this concept of equal rights into the Constitution, but empowered the federal government to enforce it. You can see the point I'm making if you compare the Reconstruction Amendments to the Bill of Rights, the first 10 amendments which protect our basic civil liberties, freedom of speech, the press, et cetera, et cetera. The Bill of Rights was based on the idea that the main danger to liberty was a too powerful national state. What are the first words of the First Amendment? Congress shall make no law. Congress. It's about the federal government. It has no bearing on the states. It didn't restrict the state governments. Try to give an abolitionist speech in South Carolina before the Civil War. You couldn't. It was against the law. Well, didn't that violate the First Amendment, freedom of speech? No, because that's a state law, not the federal government. But now, all three of the Reconstruction amendments end with a section saying, Congress shall have the power to enforce this amendment. From Congress shall make no law restricting the government to Congress shall have the power. We're talking about power today. This enhances the power of the federal government to protect the basic rights of all Americans against violation by the states. It made the federal government, in the words of Charles Sumner, the custodian of freedom. The 14th Amendment did not say anything directly about the right to vote, but very quickly, in 1867, Congress decided that the all-white governments created by Andrew Johnson were just no good, and they required them to be basically abolished and replaced by new governments with, for the first time, African-American men voting alongside white Southerners. This is the beginning of what we call radical Reconstruction. And then in 1870, in the 15th Amendment, the principle of black male suffrage was extended to the entire nation. The 15th Amendment bars states from depriving any citizen of the right to vote because of race. This sounds very sweeping, and indeed it was. At that time, only a handful of northern states allowed black men to vote. Illinois did not allow black men to vote until the 15th Amendment. But the 15th Amendment outraged the women's rights movement because it said nothing about discrimination based on sex. It barred discrimination in voting based on race, but left the states free to continue to bar women, as all of them did at this point. And even regarding men, the radical Republicans wanted a positive amendment, a different language, stating all male citizens 21 years or over have the right to vote. If that had been enacted, it would have barred a lot of legislation over the next 150 years that restricted the right to vote. But so what is the difference between saying every man has the right to vote and saying you can't deny the right to vote because of race? The 15th Amendment left open other restrictions, such as poll taxes, literacy tests, things like that. which, although not written in racial language, would primarily affect African American voters in the South. The result was an amendment whose purpose could too easily be circumvented, as indeed is happening in some states today with all sorts of new restrictions on the right to vote. As long as they don't specifically mention race, the Supreme Court has said it's not a problem under the 15th Amendment. But so the advent of black suffrage inaugurated, as I said, this period of radical Reconstruction when new biracial governments came to power in the South, an unprecedented experiment in democracy, genuine democracy in this country. And these governments had many achievements, which I can't go into now, but also failures. One might say that in Reconstruction, the political revolution went forward, but the economic revolution did not. African Americans remained poor, lacking in property. They didn't have the economic wherewithal to, in a sense, fully enjoy the freedom they had acquired. But the political revolution was dramatic enough that it inspired, as I mentioned, a wave of violence by the Ku Klux Klan and others. This, coupled with a beginning of a retreat in the North from the ideal of equality, undermined them, and one by one, the Reconstruction governments fell by the wayside until by 1877, every state in the South was back under the control of white supremacist governments. And in the next generation, up into the 1890s, a new racial system was put in place in the South, what we call the Jim Crow system. It included racial segregation, the disenfranchisement, taking the right to vote away from black men, a severe cutback in public funding for black education, a segmented labor market in which the good jobs were basically reserved for white workers, and policing the system, lynching, extra-legal violence. And the alleged misgovernment under Reconstruction became part of the intellectual justification of this Jim Crow system. Didn't this racial system violate the Reconstruction amendments, which required equality before the law? Ultimately, it fell to the Supreme Court to construe the constitutional amendments. And over time, the court played a crucial role in the long retreat from the ideals of Reconstruction. The process was gradual, not just at one moment. Each decision involved its own laws and facts and precedents. Recent scholars have attributed the retreat not only to judicial racism, of which there was plenty, but also the persistence of federalism, fear among the justices that too great an expansion of nationally enforceable rights would undermine the powers of the states. But for African Americans, the practical consequences were the same. The broad conception of constitutional rights with which they and their allies had attempted to imbue the abolition of slavery proved tragically insecure. And this is another lesson for us of the Reconstruction era and its aftermath, that in the hands of a conservative Supreme Court, constitutional rights are not necessarily guaranteed. A series of interconnected questions cried out for resolution. How substantially had the amendments altered the federal system? Did the 13th Amendment prohibit only chattel slavery or extend to what they called the badges and incidents of slavery? What were the privileges or immunities of citizens guaranteed in the 14th Amendment? What did equal protection of the laws mean, and did it apply only to blacks or to all Americans? Did the 14th Amendment protect African Americans against violation of their rights by private individuals, or only by state governments? Because it says no state shall do this or that. Did these rights encompass what blacks called public rights, the right of access to transportation, to theaters, to restaurants, to hotels, public accommodations? Did the 15th Amendment, prohibition of disfranchisement on account of race, did it prohibit laws that were race neutral on their face, but were clearly intended to eliminate black voting? I'm not going to go through case by case by case, but on all of these issues, the court chose to restrict the scope of the second founding. By the early 20th century, the 14th and 15th Amendments had become dead letters throughout the South. When the court in 1903 threw up its hands and said that if the whites of Alabama wanted to just take the right to vote away from blacks, there was nothing the Supreme Court could do about it, a northern newspaper declared, "We are brought face to face with the consideration that the Constitution may be violated with impunity." The result demonstrated a sometimes forgotten point. Our Constitution is not self-enforcing. It's worth noting that the Supreme Court's interpretation of the Reconstruction Amendments was powerfully influenced by an emerging national consensus, at least among whites, that Reconstruction had been a serious mistake. And then in the early 20th century, the Dunning School, historians, as I mentioned, came along with a scholarly underpinning for that denunciation of Reconstruction. And well into the 20th century, the Supreme Court relied on the Dunning School outlook in interpreting these constitutional amendments. In a dissent in 1945, Justices Owen Roberts, Felix Frankfurter, and Robert Jackson wrote that it was, quote, familiar history that Reconstruction was motivated by a vengeful spirit on the part of Northerners. In fact, it was so familiar that they felt no need to cite any work of history to justify this claim that Reconstruction was just vindictive, but that outlook certainly didn't lead them to take a broad, sympathetic view of the 13th, 14th, and 15th Amendments. But in the late 19th century, a different rights-based constitutionalism emerged among black activists and their allies that rejected the key tenets of Supreme Court jurisprudence. And I talk about this in my book. In 1889, a group of black ministers and lawyers in Baltimore who called themselves the Brotherhood of Liberty published Justice and Jurisprudence, a 600-page book that was the first critique, sustained critique, of Supreme Court rulings based on these amendments. The author proposed an alternative reading of the amended Constitution based on a broad conception of federal enforcement power and a rejection of the limitations on the rights that came with those amendments. It demanded public rights, in other words, the rights to access to public accommodations. It said that the privileges or immunities of citizens included not only equal treatment in public accommodations, et cetera, but employment discrimination, barred employment discrimination, housing segregation, exclusion of blacks from labor unions. These were the rights of citizens. Can a citizen, they asked, be daily excluded from the paths of industrial progress and yet be a citizen of the United States? So their view was that citizenship is deeply meaningful. The Supreme Court had basically stripped citizenship of most of its substantive rights. Overall, as one reviewer of Justice and Jurisprudence wrote, too many rights had been lost as soon as they reached, quote, the grave of liberty, the Supreme Court of the United States. Today, this country has gone a long way toward fulfilling the agenda of Reconstruction. Yet paradoxically, the recent history of the amendments reveals their ongoing expansion to protect the rights of other groups of Americans, yet a restricted application to questions involving race, such as on affirmative action or limitations on the right to vote. This reflects in part the enduring impact of the earlier decisions limiting the scope of the second founding. Our jurisprudence is based on precedent, and there's a whole long train of Supreme Court decisions that, in my opinion, are just wrong, but nonetheless, they are still good law. They were never repudiated by the court, and they still have helped to shape interpretations of the 13th, 14th, and 15th Amendments. Even the Warren Court in the 1960s, which dismantled the legal edifice of Reconstruction, never confronted the existing jurisprudence, except in Plessy v. Ferguson when they, except in this, in Brown v. Board of Education when they overturned the separate but equal Plessy v. Ferguson in regard to school segregation. Otherwise, they just worked around the existing decisions. They could not bring themselves to say that for 80 years the court had been wrong. One of the good examples of that is when the 1964 Civil Rights Act, barring discrimination in public, by businesses, public accommodations, when the Supreme Court upheld the constitutionality of that law, they didn't do it under the 14th Amendment, which they should have. They said this is allowed by the Commerce Clause, which allows Congress to regulate interstate commerce. Anybody who thinks that black Americans were in the streets in the early 1960s facing police assaults and fire hoses, etc., in Birmingham and other places, that they were in the streets in order to facilitate the free flow of goods between one state and another, doesn't know anything about our history, and yet that is the Supreme Court's view, which makes them look ridiculous, in my opinion. But my point is there is another jurisprudence, a shadow jurisprudence out there that was actually advanced at the time in the 1880s. It's not something just invented today by law professors, which takes a much broader view of the privileges or immunities of citizens, the power of the federal government to protect the rights of all Americans, and maybe a future Supreme Court in a different political atmosphere will really repudiate the old jurisprudence and adopt a much more expansive view of the rights that these amendments are attempting to protect. So let me just finish by saying that so long as the legacy of slavery and of Jim Crow continue to plague our society, the era that followed the Civil War can still serve as an inspiration for those of us trying to achieve a more just society. So thank you very much for listening. Thank you.
We're going to go ahead.
Thank you very much. So let's see about questions. I think if anyone has a question or comment, please raise your hand, and let's see. There's one gentleman.
We're going to,
okay.
Sorry, could I get the mic, please? Thank you. So we've got a couple of mics circulating on either side. A few things before we get started with the Q&A. Please do speak into the microphone so that everyone can hear. Be brief so we can get to everyone, and please pose your question as a question rather than a statement. We'll start, where did you want to start, Eric? Right down here?
Go ahead.
Professor, thank you very much for your presentation. You spoke a lot about the 14th Amendment's Equal Protection Clause and some about privileges and immunities. What about the extension of due process to the states? That turned out to be very significant, especially in the 30s and 40s.
Yes. The 14th Amendment also says that no person, not just citizenship, the states cannot deny to any person the life, liberty, or property without due process of law. When the 14th Amendment was passed, the main author of the first section, John Bingham, said the purpose in part is to make the states abide by or respect the liberties in the Bill of Rights. As I said, that had previously been only applying to the federal government. And that would happen through the Privileges and Immunities Clause. In other words, these are the privileges and immunities of citizens: freedom of speech, trial by jury, etc. But in one of its very first decisions, the slaughterhouse cases, even during Reconstruction, 1873, the Supreme Court said, forget about the privileges and immunities, there aren't any. Everything is still in the hands of the states. You don't get anything in terms of rights from being a citizen under the United States. They completely eviscerated that clause so that it's barely ever been mentioned again in any Supreme Court decision. In the 20th century, you said, the Supreme Court slowly began to apply the Bill of Rights to the states, one by one, and it's still going on. Not long ago, there was a case about excessive fines or something. And it now said, that's, I don't know what amendment, Eighth Amendment or something. The Supreme Court said, no, the states have to abide by that restriction. You can't impose excessive fines on people. So that's like 150 years after the 14th Amendment. So yes, the Due Process Clause has been used to incorporate the 14th Amendment, but it's the Bill of Rights, but it's another example of how the recent Supreme Court has been afraid to go back to those early decisions and say, hey, Slaughterhouse was just wrong about privileges and immunities, and it makes no sense to say that the Bill of Rights is a question of due process. No, those are substantive liberties that need to be protected, and a process is not the problem, whether it's a good process or a bad process. So yeah, I don't want to go into more complexity on this, but it's another example, in my opinion, of how Supreme Court jurisprudence has been warped for many, many decades in interpreting the 14th Amendment. And the other point, of course, is that without any grounding in the history of Reconstruction, they have also applied the Due Process Clause to corporations, right? Corporations are legal persons, according to the Supreme Court, and they have all the same rights as you and I, as real people. And Citizens United, the most recent example of that. And that's what now there is no evidence whatsoever that the people who wrote the 14th Amendment were thinking about corporations. Absolutely not. But the Supreme Court wormed that in later on. So if you think I don't have a lot of respect for the Supreme Court, you are actually right.
Great. Let's take a question up there, Kelly.
So all your books are amazing, Fiery Trial. You teach us things most of us just don't have a clue of. I assume civil rights flowed out of winning the Civil War. I had no idea what a battle followed in 1866. Does the Civil Rights Act of 1866 still get ruled on in courts?
Yeah,
or was
there's
that
a case right now. It's still on the books. It's still there. There are cases. Here's a melancholy fact. The Civil Rights Act of 1866, in some ways, is a stronger law than the Civil Rights Act of 1964, 98 years later, which is the high point of the civil rights movement, and yet the penalties involved are less than in the Civil Rights Act of 1866. So, yeah, I mean, look, it's not just what the southern states were doing. As I said, the anti-slavery movement before the Civil War had developed a whole concept of what citizenship ought to be and the rights that all people ought to enjoy regardless of race. They could not implement that before the Civil War, but the people I mentioned, Bingham and Ashley, they were veterans of the abolitionist movement, and so this is our opportunity to put those principles into the national law and the Constitution. So again, to understand this, you've got to go back before the Civil War, not just look at the debates of a year or two in the 1860s.
Got a question right down here.
Okay.
Assuming that Abraham Lincoln had survived and had not been assassinated, and that we really did innovate true Reconstruction in 1865, right after the Civil War, how do you think that would have impacted on the South in terms of their immediate relationship with the North?
Okay, did people hear that? Basically, what would have happened if Lincoln had not been assassinated? This is what we call counterfactual history, right? No, it's fine. I don't mind speculating about this. After all, nobody can prove I'm wrong. But the first thing I would say is completely impossible to imagine Lincoln getting himself into the situation that Andrew Johnson did. That is completely alienating Congress and eventually getting himself being the first president to be impeached and tried before the Senate. That Lincoln was far too good a politician, far too centrally located in the Republican Party. He knew how to work with Congress. He had done it. He would never have followed the path of Andrew Johnson in that way. I think if Lincoln had lived, you would have seen, at least in the first year or so, the same measures that were actually enacted over Johnson's opposition. I mean, the Civil Rights Act was a mainstream Republican. Every Republican in Congress virtually voted for it. Lincoln is a mainstream Republican. He's not going to go against it. 14th Amendment, every Republican in Congress voted for it. Lincoln would have certainly supported it. Johnson said, No, he told the southern states, reject it. We don't want black citizenship. He launched a campaign against Reconstruction. He encouraged violence in the South. Lincoln would not have done that. So then the question is, would the white South, confronted with a united national government, with the president and the Congress working together to promote Reconstruction, would they have felt the same ability to violently oppose it? They had a president who was telling them, these laws are illegitimate, these amendments are illegitimate, you don't have to abide by them. So I don't know. I mean, what would have happened? And what would, then if you go further, then it becomes pure speculation. What would have happened in 1867, 68, when the Klan was, rampant? What would Lincoln have done, if anything? I don't know how Lincoln would have responded to widespread violence in the South. We know that later, Grant, when he was president, sent troops into South Carolina to crush the Klan. So, the funny, on the one hand, you would have had a united federal government pushing Reconstruction. On the other hand, the impasse with Johnson was actually part of the creative element of the situation. It forced Republicans to go further than they may have wanted to at the beginning. It forced the issue of black voting right onto the center of the national agenda. Without that, maybe radical Reconstruction wouldn't have gone nearly as far as it did, but maybe a more moderate Reconstruction would have lasted longer. We don't know. As I say, the first few months you can speculate. When you get 2 or 3 years into the future, it becomes impossible to know what events would have taken place and how a person like Lincoln would have responded.
We have a question here on your right.
Hi, over here. You've written so much about Reconstruction. I was wondering how you feel about the African American Museum in Washington, D.C., giving a tiny little room to Reconstruction. And have you ever discussed that with its director?
You're talking about the museum, the African American National Museum of African American Culture. You took the words right out of my mouth. I know those guys. I was an advisor on it. I knew the director. I was just there at an event 2 days ago. I said the same thing. It's a great museum. And I certainly urge anybody here who finds himself in Washington to go and spend some time there. But it doesn't deal adequately with Reconstruction at all. You're completely right. It's scattered around. There's no sense of it as a coherent time period. The economics is over here, the politics is over there, race relations over there. They are actually now working on a big exhibit about Reconstruction, which they're going to have, and I hope that'll be a temporary exhibit, but I hope it will eventually help to reshape how that museum deals with Reconstruction. I don't really blame them. It's very hard to cover everything adequately. It is a wonderful museum, but Reconstruction often does get short shrift in survey courses of American history. It kind of gets overshadowed by the Civil War. It's very complicated, that's the problem. And you're not sure whether to emphasize just failure or success or how, it doesn't have was it William Dean Howells, the novelist, said, Americans love a tragedy with a happy ending. Reconstruction didn't have a happy ending, and it's hard to quite figure out how to put it into our history, but I agree with you, basically.
We have
time
straight
for
ahead.
one last question. After the last question, please join us in the lobby for a book signing.
So, in defense of Mr. Johnson, who probably was a bad president, here.
Where are you? Yeah, okay, I'm trying to see where you are. Okay.
Yeah, so he did have one good idea, I should say. He wanted to prosecute the generals and the politicians of the South for the war, and which Grant actually did not want because he'd given Lee a word. How do you think that shaped the narrative of the South? If they had prosecuted these people, General Lee would not be the hero he is today, and it would have made a difference in the way the Reconstruction happened.
Johnson made his name. He was the military governor of Tennessee. Lincoln appointed him during the war. He was put on the ticket as vice president as a statement he was a white Southerner from Tennessee, but he stayed with the Union, the only senator who refused to leave when his state seceded. Lincoln and others thought he represented what they considered a large group of white Southerners who had remained loyal to the Union and might join up with the Republican Party once the war was over. And Johnson kept saying, yeah, treason must be made odious and traitors punished. He wanted to put them on trial, the leaders of the Confederacy. And when he began his Reconstruction plan, he said, anybody who has $20,000 or more in property can't get pardoned right away. So he wanted to kind of exclude the upper crust of the South. He was a poor yeoman, and he thought the poorer whites would kind of take over politics. Didn't happen that way. None of these people were put on trial. The only person executed for, not even for treason, but what we would call war crimes, was the commander of Andersonville Prison, a notorious prisoner of war camp for Union soldiers in Georgia, where many died, and the commander was executed for their treatment, not for rebellion against the United States. In a civil war, the point at the end is to bring the country back together. So many people, most radical Republicans, for example, were not interested in putting these guys on trial. They were interested in doing what they tried to do, fixing in the laws and the Constitution the basic rights that all Americans are going to have now that slavery is gone and the war is over. I'm not sure that Johnson's idea, which he abandoned pretty quickly in order to work with the well-to-do Southerners, would have produced a better or a more lasting Reconstruction. It might have just caused even more resentment. But again, that's speculation. We don't know. Anyway, thank you all for coming, and see you later.